What happens to an employee in a liquidation situation? First of all, there are two types of liquidation situation. You have the compulsory liquidation, which is a court-driven process. An employee or employee contracts in that situation automatically terminate when the court grants the winding up order. With a creditor's voluntary liquidation, the timing of the redundancy of employees will depend upon the requirements of the company. The directors who control the process should consult with the insolvency practitioner concerned, who will become the liquidator, to determine if there are any contracts that are required to be completed or any services that the employee individuals can provide during the period leading up to liquidation. The key factor for the directors in this process is ensuring that they are in a position to pay the employees for the work that they undertake during that process and other costs that are required for them to continue in employment. The driving factor will be if, as a result of this continued work, the employees safeguard and preserve the assets in some way by completing some works and making a sale which generates increased revenue and increased realisations to enhance the position for creditors once the company has entered into liquidation. As to the employees themselves, the employees' rights are protected by the Employment Right Act of 1996. There are four main areas where the employees have rights in this matter. There is their arrears of pay, so those wages that they haven't been paid for the work that they've done. There are arrears of holiday pay, entitlements that they haven't received. And then there are two termination payments which they're entitled to. One is redundancy, which all employees are entitled to as long as they have been in employment for 2 years. And the other is notice pay. Notice will either be on a statutory basis, which is effectively 1 week for every week worked after they've been in employment for 1 month, and their entitlement there would be that they would be entitled to 1 week for every year they have worked, up to a maximum of 12. With redundancy, this is again a statutory entitlement, and they will be entitled to receive 1 week's pay for every year they have worked once they have been in employment for 2 years. There are some anomalies or some difference in the calculation depending on your age, but those will be covered by our fact sheets that you can see on the website. So, if you have any queries on the subject I've just discussed, then you can visit the website at www.chamberlain-co.co.uk, or alternatively you can contact the office on 0113 242 0808 and speak to one of the team, who will be only too happy to help you with your inquiry.